Let me see if it shows that in this. They do. Marietta has it.
Ms. Collins, you're on position 2.
Okay, so this is Mr. Smith, right? Paul Smith?
Yes, Your Honor.
Okay, this is position 3. Let's see, 23 CP 217615, 67 days without indictment. There's no bond as of April the 13th, and there's theft by taking felony. And Ms. Kennebrews here in Mr. Cazzoli's stead, and Ms. Kennebrew is waiving prelim. They're signing that, and Ms. Watts, we'll leave it over here on the desk in front of me so that we'll file it in the morning, Ms. Kennebrew. And she wants to be heard on bond. Pre-trial.
Josh, give me 1 second.
Okay.
GCFC is moving a little slow there.
Sorry, it's a little loud in here. I can't hardly, but I think you should give me a second. And Ms. Watts, while you're listening, the case that's assigned to Mr. Houston, Joshua Lattimore is going to need a conflict or C3? Conflict? Going to need a conflict.
I believe so.
Is anybody still going to argue bond for him or no?
I don't think it would be appropriate.
Okay. I don't know the conflict, so yeah, okay. Y'all got a co-defendant?
I'm not exactly sure.
You just know it's something, right?
Yeah,
Okay.
I filed this motion for preliminary hearing, so.
Yeah, oh, and that was, yeah.
Josh, give me 30 more seconds. It's loading.
Oh, you said one more second? Oh, okay. Oh, yeah, that was Mr. Lyle, and I don't know. Yeah, so Mr. Lyle's the one that filed it, Ms. Watts, so it's already assigned to conflict, that one, so I guess we'll just need to reset it. With Joshua Lattimore, but we'll bring him out and tell him. It's just 66 days, so we'll get a date.
I don't think so.
And he has 8 cycles, 2019 burglary conviction out of Cobb County. He appears to be on probation. It was a 5-year probation sentence. Aggravated assault conviction, 2019, also out of Cobb County, also maybe on probation for that case. It was a 5-year probation sentence. 1 probation violation, possession of meth conviction out of Cobb County, 2021. A 2nd probation violation out of Cobb County, and nothing further.
All right, Ms. Kennebrew?
Yes, Your Honor. Mr. Smith has been in custody for 67 days as of today's date. He is 37 years of age. He is here on an alleged theft by taking. He has been in Georgia for the past 6 years. He does have a valid address. He did attend college. He was a freshman in college until about a year ago. We are asking for a UJR to his hold. He has a hold out of Marietta. If you are not inclined to do the UJR to the hold, then we will be asking for a bond not to exceed $5,000 so that he can get into a treatment program that Attorney Cazzoli has been working on.
All right. Ms. Patton?
I'll consent to the 5,000 and the treatment program. And Ms. Kennebrew, if he is accepted into that treatment program, if things need to change, Mr. Cazzoli can email me
Okay.
about that specifically.
But we would prefer the UJR, Your Honor, if you're inclined.
So you want to do that same thing that we did this morning?
I don't quite remember.
But we did like the 5,000, and then if the hold doesn't come get him, if it's a UJR, unless the hold doesn't come get him, then it's 5,000.
We will be amenable to that.
Who was that?
I don't know. I hear, it sounded like they were like right here.
Yes, Your Honor, that's fine.
And where's he gonna live? Do you live in, let me see, this address is a Sumac Drive.
It's going to be in Marietta, Your Honor. It won't be in Fulton County.
Okay. So, no drugs unless prescribed, no alcohol, no weapons, stay away from 1345 Piedmont Avenue. No further contact with Mark Myers, Myers. Stay away from 589 Elmwood Drive. Stay out of Fulton County unless you're here for court. See your lawyer, or if by chance if he gets him into that program, we'll do that, okay? court lawyer. Don't stop for gas. Don't stop for anything to eat. You can have an ankle monitor paid for by the county, a 24-hour curfew, court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, exact location you'll be working, basic life necessities, and if you get into a program, working that program. So it'll be a $5,000, but a UJR to that hold. So once you get released from that hold, if they pick you up, you have to report back, get an ankle monitor placed on your ankle, okay? If you don't, that'll be a violation and they'll revoke it and then you'll come back to Fulton County. Best of luck to you, sir.
Your Honor, that's a UJR jail to the whole.
Right, UJR jail to the hold, but if they don't come get him, it'll be 5,000.
Okay, thank you.
How long do they wait before they do the bond? Do they have a time on when like Marietta can come get them?
I don't know how long they wait.
I think it's like 15 days, but I don't really know, because some people have been staying longer than that,
Yeah.
Even when they've been released to the hold?
even when they've been released to the hold.
I think they try to do it where they have it. Maybe if it's Marietta, since they're housing people up there, they'll do it. But sometimes they come, wait until there's 2 or 3 and come get them at the same time. All right, and he's on. Sure.
I didn't read what you just had in front of me. Okay, I'm trusting you, but
Yeah, girl.
I just didn't
Oh, yeah.
even
you want-
look down
I don't
at
need to
it.
sign it, right? You can just leave it. Yeah, leave it there. Miss Butts will get it tomorrow. So we got Glentavious Vaughn.
Latavia's phone. Got Vaughn.
That's the case you're here on, right? All right, come on up. Do we know? Let's see, looks like that might be another.
Um,
Oh, no, it's
I
not.
have some other stuff to clear out beforehand that might be fast.
Okay, all right.
Just position number 1, I do know that officer's on sick leave. Officer Gibbs, GIBBS for Harold Norris. So the state would be asking for a reset so that he's, time to get better and time to be present.
All right, do you want to, you want to tell him to stop and bring Mr. Norris? Let me tell him, you can sit right there. He can just stand there, Ms. Kennebrew.
Okay.
Your Honor,
Yeah, that way we can
that
tell him it's gonna be
position,
recent.
number 1 was declined to prosecute on yesterday, on the 13th.
Oh, was there? Hold on.
From
On all the
yesterday?
charges?
For
No, Harold
Norris.
Norris, he's out. He's out. Yeah, he is out. Sorry. He's not in there. Sorry, deputy. Yeah,
Oh, he
Need to
was
pay-
released?
yeah.
All righty.
So what about position 2? Anything?
No. We would just be asking for a reset, but I'm still checking to ensure when
It was my bad, deputy. That one's out. Yeah. So do you want to go ahead and hit that one, Miss? All right. Sorry, Miss Kennebrew. We bring out Tamias Reed. Sorry, that was my bad. I said bring him out. Tamias Reed. Tamias Reed, REED. We'll go ahead. Let's see. I don't know if he. Yeah, he's in no bond, so.
Just calm. You're gonna wait for it. I just, before I start talking.
I don't think we need to, because there's not gonna be any defendants out
Okay.
besides him, of course.
What is he on the no bond status?
I mean, is there any, would you be willing to waive, consent to a bond, would you waive anything?
I will, but I'm not gonna consent to a UJR. Like that.
Let me.
You wanna come right here?
Let's see what happens.
Right here, right? This way, this way.
Until we talk about
Right
this meeting. Yeah, but the problem is that. I don't see that in the warrants. That's what we're getting discussed, so I guess we're here today.
Okay.
But, let's see what happens. I'll probably end up getting.
What are you asking?
I need to talk to him.
Okay.
That's why I said maybe we can talk afterwards, 'cause I was expecting it to. I'm just. Okay. See.
We'll do, yeah, just email me. paper. Let me just read it again quickly. It was really short. Disgusting. But it said 25 and 5. Lazarus. He's Lazarus. Yeah, yeah. But he doesn't have any like sea life case. No, this is the first time it's been a case. Okay. He can't talk. Okay. Only thing that's kind of hard to work around because I don't know if they can do specific. Like, I don't think they can name minor exceptions. I was just saying, oh
Judge, we may have a possible waiver of prelim for consent bond.
Okay,
We'd just like to put it in front of you regarding some conditions that we weren't really able to agree on.
okay, all right. All right, this is position 2, 23 CP 217613, 66 days without indictment. Right now, it's in no bond status. Do you want to waive?
The reading of it, that's fine, yes.
Okay. And then, of course, sir, you know your two charges. Okay, go ahead.
Your Honor, I have been speaking, me and the ADA have been in contact, and we're willing to agree to a bond amount of 20 on count 1, 5 on count 2. Conditions that we would agree on is an ankle monitor with a 24-hour curfew, no contact with the victim or the victim's family, and to stay away from the incident location. We are asking the issue that we're really stuck on is contact with minor children. We're okay with that, except that Mr. Reed does have a minor child living in his household. It's his nephew. And so we're okay with the no minor contact with minors. We would just want an exception for the minor child that lives in his home so that he would not be homeless.
And Ms. Patton?
Your Honor, I didn't know a way around that. It is important to have that provision and understanding that we've waived a reading of
Right.
what's going on. Honestly, I was looking to Your Honor if there was a way around that one.
I mean, I think we could put with the exception of that child's name. That's it. Is that the only child, sir? Oh, I mean, and this includes if, is like, do you live with a sibling and that's how,
I mean, it's my sister.
so you live with your sister and it's your sister's? Oh, okay. So are you the guardian over your sister's son? Oh, okay, so you live with your mom and the nephew lives there because of that. And mom's not in here in the courtroom, right? Oh, okay. So it would be, like if, how old's your nephew? Oh, okay, so he's really not gonna have like friends over hanging out probably, because, okay. That would be fine if you put, what's his initials? KLR. Kilo Lincoln. Right? You said K, right? Like, okay. All right. Yeah, that'll be fine. As long, and we'll just say with your nephew initials KLR, Kilo Lincoln Roger.
Would you happen to have like the bond forms so we could kind of like,
Well, she'll email it to me. So Miss Williams, so it'll be 20,000. Here you go.
On
Here's
count
the,
one.
you want the waiver? It'll be 20,000 on count one, 5,000 on count two. No drugs unless prescribed, no alcohol, no weapons. Stay away from 5775 Blacktop Court in Union City. No further contact with Jessica Cofield or family members of Jessica. Ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment, schedule, exact location, you'll be working in basic life necessities. He can, however, have contact with his nephew, initials KLR. You got that, Ms. Williams? Make sure it says that, but no further contact with anyone under the age of 17, with the exception of KLR.
Your Honor,
Yes,
may I
Your
put
Honor.
on the record as to my position as to the consent agreement?
Okay, sure, yeah.
Yes, Your Honor. I did speak with Ms. Collins at length about this case. She did assure me that there's no similar case like this in this defendant's history. She also assured me that there are some problems, or she believes there to be some problems with the warrant. Our officer also is currently not present to testify on behalf of that. I also looked a little bit at this defendant's history himself. He has nothing like this in his history. Nothing in his history suggests violence of this nature. And if you look at the charges that are listed, again, understand we waive sounding. I do not think this defendant, Ms. Collins has assured me this defendant doesn't have an issue speaking to the victim anymore, doesn't have an issue with any of the conditions of staying on an ankle monitor and keeping himself from committing further felonies while he's out on bond.
And he's not gonna live in Fulton County, right?
he lives in LaGrange.
Okay, yeah, so you stay out of Fulton County. Ms. Williams, he can only come back to Fulton County for court or to see his lawyer. But
Yes, Your Honor.
anywhere you have to go, let's say, heaven forbid, your mom gets sick. If you have to take her to the doctor, you need, your first call needs to be the ankle monitoring company saying, taking my mom to the doctor. Your second call or email, probably, I'm sure Ms. Collins doesn't have time to field all the calls. She'll give you her email her and say, on this date, at this time, I took my mom to the doctor on this address. And that way, if something comes up, there won't be any confusion. So however she wants you to let her know about your moves if you have to, okay? And make sure you keep it charged. And that's fine. So we'll put that in place, but no further contact with anyone under the age of 17 with the exception of your nephew, KLR. Ms. Williams, you got that?
All right, Judge, I've been informed that his first child is gonna be due sometime this month.
Did he have initials for his first child?
I don't know, because the child hasn't been born yet, so I don't know.
Some people
They're
know
on
their name.
Sunday.
Sometimes they know their name ahead of time.
What is this one's initial?
DJ.
What is it?
Okay. Okay, or contact with his newborn. Congratulations, sir.
Don't
initials are-
change his name.
Yeah, don't change this. Now, if she,
TNR.
TN, is he a junior? Oh, okay, I was gonna
Well,
say
just
now.
Don't change his name because
Yeah,
then
so
there won't be a
initials
problem.
TNR. So, sir, I'll also let you go. I mean, if you're going to be there for the birth of your child, I'll let you go for the birth of your child.
What is it? TJ or TN? Okay, all right, TNR.
T is in Tom, N is in Nancy. Ms. Williams, did you get all that?
Yes, Your Honor.
Okay, so you can leave for the birth of your child too, sir, to go to the hospital or wherever, but then you have to, so those are the only two people you can have contact with is under 17, okay? All right, well, congratulations on the. And now, let's see. So what about, the Jason Clerk one? Let's see, is that, because the officer's not here on it. Yeah, we'll bring clerk out since. If you want, I'll take a picture of that bond order before I sign it and send it to you. Or if it's in here in the queue before you leave, I'll let you come over here and read it.
I just wanted to know who's gonna be taking it.
Yeah. Now, this is Mr. Clerk, and he has a $5,000 bond as of April the 12th. Did you already speak with Ms. Patton?
Mr. Clerk,
No, did you speak with Ms. Patton about Mr. Clerk? You already talked to her about the case? I didn't know if it was
I
something.
have not speaking with the prosecutor, Your Honor. Today is just a preliminary hearing, is that correct?
Yes, sir. We don't have an officer. I didn't know if you'd worked anything out as far as waiving the prelim or going forward. Oh, this is a charge in jail. Okay.
Yes, Your Honor.
What
Okay.
does he have on it, a $5,000 good bond?
Yeah, it's 5,000. What's his?
Snatch the phone from the wall.
There's so much writing all over the intake sheet. I can really, let's see. Oh, is he in on the 18 SC case waiting on the trial?
The ag assault?
Yeah,
I'm not sure.
yeah, it's under Judge Kraus. It looks like he's got that and another 22 CP. All right, let's see. This is Jason Clerk, 23 CP 217619. He has been in a total with all of his charges, not this charge. He's been in at 1,824 days, but not on this. This incident was April the 11th of 2023, interference with government property. Ms. Patton?
Yes, Your Honor, the officer, Fulton County, Kenio Mike, is not present. I do believe subpoenas were sent out, but the state at this time would be requesting a reset. However, I would like to, if I could, pre-trial with the defense attorney in this case.
Okay.
Is Your Honor amenable to that?
Sure, yeah, I'm sorry. Yeah, you two can go ahead and chat if you'd like.
Okay. Does he stay here until I?
Yeah, the deputy was, yeah, you could. Ms. Collins, did you talk with Mr. Cody, your other client, by any chance already? Oh, okay. We'll get to you in just a second, officer. Thank you for being patient. And Cody's on no bond also.
Oh, this. I'll run to both of these cases. Yeah. Which, this case here? Two. That'd be good. Why is that?
Judgment, and that bond order is in there also if you need to look at it.
Okay. Ms. Collins, you want to come up here and check it out?
So these holes.
Make sure make sure the wording looks okay. You want to come look at the order before I sign it?
I don't think they're. Yeah.
Can you see it? I can blow it up.
That's better. I can see it.
You want her to add, he can go for the birth of Miss John.
It's in there, Your Honor.
Oh, wait a minute. Did I just not look at it? Maybe I'm reading it too fast.
Yes, it's for the child.
Oh, okay, thank you. Okay. Okay. Ms. Williams is always super squared away. She keeps me in line. All right, did you two work something out, or what are we doing?
Unfortunately, we were not able to reach a resolution. I would be requesting for the court to do a reset for this case so that I can see about getting an officer present.
All right, go ahead, counsel. I'll hear from you.
I object to the reset. The officer was properly subpoenaed from what I understand and should be here. And I don't know if an explanation has been provided to the court why the officer is not here. I move for dismissal for wanted prosecution.
All right, so I will give a one-time and one-time only reset, and counsel, don't forget to file an entry for me. Do
Oh,
you
I
have,
filed the entry. I did, well,
I don't know, but yeah, it's not in here yet. You may have filed it, but it's just not in here
okay.
yet. So do you have leave or anything planned? Because we'll get a date from Ms. Watts. Ms. Watts, what's a date for a reset?
June 30th at 1 p.m.
You want to check your calendar?
I will, Your Honor. I do have leave, but that's not until August the first, from the 1st to the 14th. Let's see, June 30th.
At 1 p.m.
I'll be in the building already, so that should work.
Okay, June 30th at 1 p.m. And he still has you still have your $5,000 good bond. All right.
Excuse me, Your Honor. Counsel for the defendant, may I have your name, please, for the record?
No, I forgot to just.
Counsel, can you go ahead and put your name on the record for the court reporter?
I'm sorry. My name is Joe Louis Brown Jr. and Louis is spelled Louis.
Great. Thank you, Counsel Brown. Thank you.
You're
Your Honor.
welcome.
All right. So, yeah, June 30th at 1 p.m. That works for you?
Yes, it does, Your Honor.
Okay. All right. Good to see you. Have a good one.
Great to see you, Your Honor. Have a good day.
All right. You too. All right. Let's see. So what about Tori Cody? Tori Cody. He's no bond.
Same bond we had.
calendar. And you're on the night, Ms. Patton?
No.
Oh, no, something on there.
Mr. ADA Marquez is on tonight.
Oh, okay.
Go this way. Sit right here.
All right, this is position 5, Tori Kente Cody, CODY, 66 days without indictment. There's no bond as of April the 12th. Purchase, possession, manufacture, distribution, sale of marijuana. Possession of controlled substance, Schedule 5, possession of controlled substance in Schedule 1 or 2 with intent to distribute, possession of controlled substance in Schedule 1 or 2 with intent to distribute, possession of controlled substance in Schedule 1 or 2 with intent to distribute, possession of a firearm by a convicted felon, and possession of a knife or a firearm during the commission of or attempt to commit certain felonies. Ms. Patton?
Yes, Your Honor. As of 1:39, the officer is not present. The state would ask for a one-time reset to see if we can locate the officer. I do believe he was subpoenaed, but I believe as an earlier calendar, I believe he was subpoenaed and APD has a rule about 3 days, and I'm not certain that it was in time for that.
All right, Ms. Collins?
Your Honor, we would just object, of course, for the record and just ask for dismissal. Mr. Cody is here present, and there is no witness here to present any evidence against him through no fault of his own.
All right, we'll give that one-time reset only for the officer to appear, and let's see, what date do we give on the other one? Wait, you're going on the second week of July on vacation. What date is this one, Ms. Watts?
June 30th at 1 p.m.
That's good, Ms. Collins?
Yes.
Okay, June 30th at 1 p.m. Sir, we'll hear your, the preliminary on June 30th at 1 p.m. And it's no bond as of April the 12th. And we're looking at allegedly 2,786 grams of marijuana, extra amphetamine, 24 grams. All this is allegedly MDMA, 26 grams, 2 bottles of promethazine, a 9mm firearm, 2 cell phones, 38 grams of mushrooms, and $1,526 total in cash. All of that, of course, is alleged. Number 5.
39 cycles. A 2018 conviction for criminal damage to property, false imprisonment, and 2 counts of aggravated assault. Total of 5 probation violations, 3 FTAs. 2002 conviction for sale of marijuana. A second 2002 conviction for sale of marijuana. And nothing further said.
All right, go ahead, Ms. Collins.
Yes, Your Honor. Mr. Cody is 43 years old. He resides at the address on file, which should be the Sim Street address. He's lived at that address for 6 years. He's lived in Georgia his entire life. He's a father. He has his GED. He's been working in the landscaping industry for 6 years. Your Honor, we're asking if you would consider a reasonable bond. We understand it's not a preliminary hearing. We do anticipate the day we will be able to argue for a prelim, but I would let you know that this is a case of constructive possession. None of the illegal substances were found on Mr. Cody's person. All that was found on him was $278 of cash. It's just unfortunate that he happened to be at the incident location during a search warrant being effected. But Your Honor, this is a co-defendant case. Co-defendant received the bond at first appearance. That bond was $91,000 and the co-defendant bonded out 2 days later. We're just asking if you would consider a reasonable bond for Mr. Cody. He's been in for 66 days now. We'd ask if you'd consider a $5,000 bond on the marijuana. We understand that there's an allegation of over 2,000 grams, but majority of those grams were hidden in a location, hidden within the house, and Mr. Cody was not found in the house at all. We'd ask if you'd consider $5,000 on all of the VGSA counts. Really, we'd ask if you'd consider $5,000 on all of the charges, Your Honor, for a total bond of.
All right, Ms. Patton,
Your Honor, does Judge Glanville's order?
just pulled it up. Let's see.
Okay.
Just had it open, actually. He just did it. Let's see. All right, so this, let's see. Says equal to or greater than 10 pounds, but less than 2,000 pounds is 25,000. And then. Which other one do you want? MDMA, 25,000 for equal to or greater than 28 pounds. Schedule 1 or 2. 28 grams or more is 100,000. Less than 28, but greater than 14 is 50. Heroin, cocaine.
And Judge, I would just note that the amounts in the order are really just recommendations. They're not absolutely required to be set by that number.
Contagious, that's the co-defendant, right? Contagious. Hold on. Looks like Mr. Contavious, yeah, like Ms. Collins said, got 91,000 with 10, 1, 50,000 on 10 on the marijuana. Schedule 5 was 1, Schedule 3 was 50. Number 4 was 10,000, 10,000, 5 and 5.
And I would just also note regarding the order in marijuana, it suggests 25,000 for the minimum of 10 pounds. Here, we don't have even close to 10 pounds.
Whenever you're ready, Ms. Pat.
Your Honor, I don't have a copy of that order. The state is asking that you apply those to those that order. I think you mentioned the order follows the MDMA and the marijuana, and I didn't quite catch what else it follows.
I'll forward it to both of you. Both got your laptop, right? There you go.
Yep.
Did y'all both get it? Did it get there?
Yeah, I just
Okay.
got it.
Okay. Marijuana. Your Honor, for the purchase, possession, manufacture, distribution, or sale of marijuana, state is recommending 7,500. I'm still working my way through the other ones, but I was trying to do the ones that didn't apply to the order first. For the possession of firearm by a convicted felon, state is recommending 7,500. For the possession of firearm or knife during commission, state is recommending 5,000. MDMA. Or the MDMA, which was 26 grams, state is recommending okay, looks like it would be, based on the order, it would be 50,000. Okay, there's 3 counts of Schedule 1 and Schedule 2. I'm just trying to make sure these numbers are right. For the dextroamphetamine,
Dexter,
is a schedule, it's 24 grams. $50,000 as recommended by the Judge Glanville's order. For the 2 bottles of promethazine, which his order doesn't control, 2,500. For the psilocybin mushrooms, 38 grams. Based on his order, the recommendation would be 100,000. And I think that's all of them. MDMA, dextroamphetamine, promethazine. So I think I addressed all of them, but if I missed one, let me know.
Okay, all right, no drugs unless prescribed, no alcohol, no weapons, no further contact with Contavious Cody. Stay away from 757 Coleman Street, Southwest in Atlanta, Georgia. You have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, the exact location you'll be working, and also basic life necessities. So I'll go, 5,000, 1,000, 50,000, 2,500, 25,000, 5,000, and 5,000. 5,000, 1,000, 50,000, 2,500, 25,000, 5,000, and 5,000. Got that, Ms. Williams?
Yes, Your Honor.
All right, thank you. All right, we can bring up Joshua Lattimore next.
That concludes my business. May I be excused?
Yes, ma'am. See you later. Have a good one.
All right, thank you. Have a great weekend.
Yes, ma'am. So Joshua Lattimore and Ms. Watts, you may want to email Ms. Walker if you got it, because I think this is one that needs to be to a conflict.
Position number 6, Joshua Lattimore.
All right, Joshua Lattimore.
Okay, I can email her now.
Okay. And then what's that reset date?
June 30th, 1 p.m.
Okay. But yeah, Ms. Collins is right. Since there's a conflict, we're not going to address bond. So Lattimore, then we'll bring out Curry, and then we'll handle this last hearing since this officer is waited.
One more time, what was the date for Lattimore, reset date?
June 30th, 1 PM.
Okay.
Uh-huh. Well, no, bring him out. We're going to reset it. Yeah, bring him out. No, I just gave him one. Yeah, that's why she was doing the math. Yeah, Mr. Lattimore, we're gonna call him out and tell him we're gonna reset it. If you have Sarge, bring him out. He can just stand there. He didn't have to sit at the table.
So Mr.
Joshua Lattimore, number 6, yeah. No, we're just gonna bring him out and reset it. He needs a conflict lawyer, yeah. Yeah, just bring him out, we'll tell him.
He's not coming all the way, I'm sorry.
You Joshua Lattimore? Okay, all right, this is 23 CP 217627, 66 days without indictment, false imprisonment, robbery, battery, and cruelty to children in the third. So you're in no bond status as of April the 11th, but there has to be a conflict attorney assigned to you, so we'll bring you back June 30th in about 15 days, and we'll hear your prelim and address bond again, okay? All right, so we just emailed Miss Joy Walker, and she's the one, she'll get you a conflict attorney. My guess is you'll probably see Miss Hannah Rondon, since she's gonna be it, okay? We'll get you back and we'll address them both in a couple of weeks. All right, thank you, sir. Jamison Curry, number 7. Mom, I guess it's mom. Is it mom there? If you want to, mom. Yeah, mom, if you want to reach out to the Atlanta Conflict Defender's Office, they may tell you who actually, and probably ask to speak with Hannah Rondon. They'll probably give you a little bit more information, okay? We just can't go forward if he doesn't have a lawyer. Okay? Also on June 30th, but if you June 30th at 1 PM. Yes, ma'am. If you want to reach out to the Conflict Defender's Office, I'm sure you can Google it. And they'll give you the name of his lawyer is either going to be Brian Olive or Hannah Rondon. Mr. Olive's going on leave, so it'll probably be Miss Rondon. Yeah. Okay. Yes, ma'am. Thank you. Yes, ma'am. Take care of yourself. Mr. Curry's got a $15,000 split bond with no bond on counts 1, 2, and 3.
You know, that's the family who caught me outside earlier today.
Oh, that is?
Yeah. And then once I looked at the charges, I was like, you've got to be kidding. You got to be kidding me.
All right.
You wanna go around this way for me? Around this way to answer.
They're pretty bad.
Allegations.
The allegations are pretty bad.
All right, Mr. Curry. So this is position 7, Jamison Curtis Curry, 23 CP 217637, 65 days without indictment. He's got a $15,000 split bond. He has no bond on theft by receiving stolen property, felony, driving, fleeing, attempting to elude, possession of a firearm during the commission of a felony. He's got 15,000 total on the driving, hit and run, and reckless driving. Go ahead. What says the state, Ms. Patton?
Yes, Your Honor. Actually, may I pre-trial quickly with Ms. Kennebrew?
Yes. Do you want to hear from pretrial?
Yes, actually, I would. Thank
All
you.
right. Pre-trial.
He has 26 cycles, 2022 conviction for aggravated assault. I do not see what the sentence was. That was out of Clayton County from May of 2022. 2019 possession of cocaine conviction. He may be on probation for a armed robbery, aggravated assault, hijacking a motor vehicle, criminal damage to property, and possession of a firearm by a convicted felon. That was in 2007. It was 11 years confinement, 9 years probation. He has a burglary conviction, 2003. theft by receiving stolen properties convictions, 2004 and 2003 probation violations, and nothing further to add.
All right, thank you. Yeah, you guys go ahead. You can go ahead and chat.
Thank you, Judge.
Detective, thank you for being patient. It's easier if we get the other ones out of here, but we'll take you right after this. We'll get you out of here as quick as we can. All right.
Unfortunately, we were not able to reach any sort of agreement. The state would be requesting a one-time reset for Georgia State Patrol, Mr. Brown. Like I stated previously, I believe my subpoenas have gone out. Unfortunately, my investigator is in trial or viewing trial right now, so I don't really have a lot of contact with her. I do believe they do go out at the same time, though, just as, you know, I've been watching when they go out. We would ask for a one-time reset. And if your honor is inclined to do a bond hearing, the state's ready to proceed on that.
All right, Ms. Kennebrew.
Your Honor, we will be asking for a dismissal for want of prosecution. The officer was subpoenaed and requested to show. He didn't give a legal valid excuse as to why he's not here. So we will be again asking for a dismissal for want of prosecution, and we would also be requesting a bond hearing.
Okay, so we will go ahead and give one reset. Same reason we did before, because of the subpoenas or whatever getting out late for this officer to appear. It'll still be June 30th at 1 p.m., Ms. Watts, or is that calendar full already?
Yes, Judge, it'll be June 30th at 1 p.m.
30th, 1 p.m. And we could go ahead and be heard on bond. We've heard from pretrial unless y'all need to hear it again.
I don't need to hear it again.
No, Your Honor, we don't need to.
All right, go ahead, Ms. Kennebrew.
Yes, Your Honor. Mr. Curry is, I'm sorry. Mr. Curry, ooh, I apologize, Your Honor. Give me just 1 second. Your Honor, Mr. Curry is 41 years of age. He was born and raised here in Georgia. He currently lives with his brother and does have a valid address. He did complete high school and he was working prior to being arrested at Waste Pro, and he had been there for over 2 years. His address is going to be in East Point, Georgia. Your Honor, we would be asking for the bond not to exceed $15,000. We do have we would have had argument had the officer actually shown for a couple of the charges. The alleged theft is of a car that was from 2012. The bond is supposed to be to ensure that the defendant will return to court. So, Your Honor, we would be asking for the bond not to exceed $15,000.
All right, what says the state?
Yes, Your Honor, based upon this defendant's history, I believe pretrial mentioned a 26-cycle history with multiple thefts in his history. So I can read my own handwriting there, 26 cycles. The state would be requesting on the no bonds that he have, I believe are for the first 3 charges, that those be no less than 10,000, and the state will concede to leaving the bonds that are listed for the other amounts. We also would add the conditions of a stay away from the victim, an ankle monitor with 24-hour curfew with the exception of medical and legal, and childcare should he need it.
Bless you.
Your Honor, I need a moment.
thought she was gonna sneeze, it looked like.
Okay. We have the wrong defendant. I'm sitting up here looking at him, realizing he's not the same person.
Sorry,
This
anyway.
is, Vaughn.
This was,
This isn't Curry. That's why I got
that's exactly what that is.
confused with the age, because I'm like 41. So, yeah, I was mistaken. This is Curry.
Sorry, I have the bond order pulled up, not even,
I'm sorry, excuse me. He's not Curry, he's Vaughn.
okay, well, scratch all that. Let's just go ahead and do the prelim on bond. Put him right here.
This-
Well, was that the right facts then for Mr. Curry?
I'm assuming that was all Curry's information. Remember, I'm here in
I'm sure it was-
replacement of Cazzoli, so I,
Right.
yeah.
Yeah, come on.
But
up,
I was
officer.
looking and
Let's-
I did a double take. I'm like, this can't be the same person. He saw me enlarge the picture and he was like, that's not me.
All right, let's see. How about this? Sorry, I wouldn't even look, I didn't even, I had the bond or the former bond order pulled up, not the picture, sorry.
Okay.
All right, that's happened before, so you're Mr. Vaughn, right?
Yes.
Okay,
My mistake.
no,
Um,
okay.
That's all. of it.
All right, let's see, 23 CP 217638, Glentavius Vaughn, 65 days without indictment. We got aggravated assault and reckless conduct. And hold on. Let's see what we got here. There is on
Your
April
Honor,
4th, there's a $25,000 split bond with no bond on the ag assault. Do you still want to talk or do you want to hear from pretrial first?
Did you want to do pretrial?
Well, so this one we're doing an actual hearing on, correct?
Unless unless y'all pretrial it and she wants to waive and you get a bond, I don't know.
We could definitely pre-try it. I'm sorry, I'm still thrown by, we
Yeah, I
have
have
a
to.
defendant.
Usually I look at the picture, but I didn't. I apologize, Ms. Kennebrew. Do y'all want to hear from pretrial on Mr. Vaughn?
I do. Ms.
Right.
Kennebrew probably doesn't.
Pretrial on, how about this at Glentavius Bond? Now we got our act together.
Okay.
He has 5 cycles and no felony convictions.
No felony convictions?
Yes, that's correct.
When was the last arrest?
Give me 30 seconds to pull it back up. Sorry.
Is that in the report that says April of 2023 for marijuana possession less than an ounce?
His last arrest was April, right, that's correct, of 2023. Oh, wait, no, that's this arrest. Prior to that, April 2nd, 2023, Henry County, possession of marijuana less than an ounce. Prior to that, November 2022, Clayton County, possession of marijuana less than an ounce.
Right.
And then DeKalb 2019, misdemeanor theft by taken.
Right. He's 24 years of age. Yeah, if you guys want to go ahead and talk, maybe I'll look over the right paperwork for the right person.
Significant age difference.
okay, so Your Honor, I have one question are we still doing the one-time reset for Curry? Or are we gonna wait or what?
I mean, we will, but we'll wait and put it on the record when he gets out here. Yeah.
Okay, thank you.
We'll still do it for the 30th. So either way, that officer's still not here.
Okay.
But we'll just let him know when he gets here. Sorry about that, Mr. Vaughn. I was looking at the bond order. That was all I was looking at. Where's that noise coming from? Do you hear it too? Oh, okay. I'm like, man.
Like I'm telling them.
Hey, if you tell them keep it down a little bit, I mean, I got my hearing aids in, but then now I hear that like a lot. Thanks. Yeah, just tell them. I don't know what they're doing, but just if they keep it down to a dull roar, that'd be good. I thought I was crazy. I kept hearing stuff. I'm like, where's that coming from?
Okay, you're good over there.
Thank you. Thank you.
Okay, Your Honor, I believe we are ready to proceed. You let me know when you're ready.
All right. You raise your right hand. You swear affirmative testimony you're about to give is the truth, whole truth, nothing but the truth.
Yes, Your Honor.
All right. If you state your name, spell it for the court reporter.
Detective Carlos Snow, Carlos. Last name Snow, Snow.
All right. Whenever the two of you are ready, that's fine. Take your time.
That's only gonna happen one way. Alrighty. Okay, Detective Snow?
Yes, ma'am.
Hi, how are you?
All right, how are you?
I'm great, thank you. Where are you currently employed?
City of College Park PD,
Okay, and how long have you been employed there?
10 years.
Okay, wow, it's a long time. Were you employed there on or about March 3rd, 2023?
Yes, ma'am.
And are you post-certified?
Yes, ma'am.
Were you post-certified at that time?
Yes, ma'am.
Okay, and how did you come in contact with the accused in this case?
March 3rd, 2023, I was assigned a case involving an aggravated assault. When I conducted my investigation, it was discovered that the defendant was with his girlfriend, Rachel Goings. Rachel, that's Rachel, last name Goings, Goines, on March 3rd, 2023. The defendant rode with Ms. Goings over to her ex-house to conduct a custody exchange. While his girlfriend was conducting a custody exchange, the defendant and her child's father, Mr. Perry Mitchell, that's Perry Mitchell, Mitchell, had words with each other. The defendant got out the car and Mr. Perry walked up on him. They exchanged words. The defendant got back in the car. Ms. Goins proceeded to pull off. While Ms. Goins was pulling off, the defendant fired a handgun, fired a weapon, one shot at Mr. Perry as Ms. Goins pulled off. I obtained an arrest warrant for the defendant. He was brought in. I interviewed him. He admitted that he did shoot at Mr. Mitchell. He stated that he wasn't trying to shoot him. He was just trying to scare him.
Okay, so let's back up a little bit. You said that you received a call from Mr. Perry filed a report, and I'm saying Mr. Perry, but his name is Perry Mitchell.
Perry Mitchell.
So
yes,
Mr. Mitchell filed a report.
Yes, ma'am.
Okay, and did he come into the police precinct to file a report? Did he call? How did he do that?
He called the day of the incident. Police responded to the location.
Okay, and were you one of the police officers who responded to that location?
No, ma'am.
Who was?
Officer Armentrout, that's Armentrout.
Okay, and you're looking down now. So would you mind telling the court what it is you're referencing while you're looking down?
The original police report that Officer Armentrout did.
Okay, understood. And did Miss say the name one more time? I don't want to butcher it. Mr.
Armentrout.
Armentrout?
Yes, ma'am.
Okay. Did you discuss with him what he had discussed at the incident location?
No, ma'am. I just went back and reviewed his body cam.
Okay. So his body camera footage was working.
Yes, ma'am.
Is that in color?
Yes, ma'am.
Is there audio on the body cam footage?
Yes, ma'am.
Okay. And when you saw the body cam footage, who was the first person Officer Armentrout interacted with when he arrived at that location?
Mr. Mitchell.
Okay. And that location, what is the address for the location that he arrived at?
2210 Sullivan Road. That's located in Fulton County, Georgia. The apartments are Embarcadero Apartments.
Okay. So that is in Fulton County.
Yes, ma'am.
Okay. And how was Mr. Mitchell's demeanor from the footage?
He appeared to be upset. He was upset because he said all this took place while his kids was in the car. And he said that the defendant shot at him knowing that his kids was in the car. He wasn't that so worried about himself. It was just the point that both his kids was in the car during the time of the incident.
Did he ever state how old those children were?
No, ma'am.
And he stated they were in the car as in whose car?
And Rachel Goings' car.
Okay. And did he ever describe the location of each person in the car?
He just told me that the defendant was in the passenger seat. Ms. Goings was the driver and both his kids was in the back seat.
Okay. Did, on the body cam footage, did he indicate as to what the argument was over?
He did hint about something about tax money that him and Ms. Goins wasn't seeing eye to eye in regarding tax money.
Did he indicate why Mr. Vaughn was involved in that conversation?
No, ma'am.
Did he ever indicate why him, specifically Mr. Mitchell and Mr. Vaughn were having, I think you said they had a disagreement, what that was about?
When I spoke with him, he told me that they really both didn't too much care for each other.
Did he ever indicate to us as to why?
No, ma'am.
Just they don't get along?
Mhm.
Okay. Did, on the video cam footage or after you subsequently spoke to him, did he ever indicate to you what Mr. Vaughn physically looked like?
Yes, ma'am.
And how did he describe him?
Black male, dreads. I think he told me he was around 22, 23 years of age.
Okay. No identifying tattoos or scars or disabilities?
No, ma'am. He was able to go to, I think, Ms. Goins' Instagram page or Facebook page, and he sent me a picture of the defendant.
Did you look at that picture?
Yes, ma'am.
Did you execute the arrest warrant on Mr. Vaughn?
Yes, I did.
Okay, and did the picture from the Instagram that you saw, was that representative of the person that you arrested subsequently?
Yes, it was.
Would you recognize that person?
Yes, ma'am.
Are they in the courtroom presently?
Yes, ma'am.
Please indicate whether they are, and feel free to stand, if they are on my left or on my right, and identify them with an article of clothing.
He's on your right with a blue jumpsuit with a white t-shirt up under it.
Okay, please let the record reflect that the witness has identified the defendant, Mr. Vaughn.
Right, the record will reflect such.
Okay, so let's go forward. Is there anyone you spoke to about this incident other than Mr. Mitchell?
I spoke with Ms. Goins.
Okay, and what did she indicate?
She came in and I asked about the incident. She did inform me that she took the defendant over there with her to pick up her kids at the location. She stated that that wasn't her intentions, but I think that Mr. Mitchell just called her out the blue and she just so happened to be in the area. She said once that they arrived at the apartment complex, the defendant and Mr. Mitchell had words with each other. She stated that she told the defendant, to get in the car, leave it alone, leave it alone. She stated that after she finally got the kids in the car and the defendant got in the car, she attempted to pull off. And that's when the defendant fired one shot at Mr. Mitchell. She also stated that he wasn't shooting at Mr. Mitchell. He was basically just trying to scare him.
Ms. Goins indicated that.
Yes, ma'am.
Did she tell you how she knew that?
Yes, ma'am. She was in the car. She was the driver of the vehicle.
I mean, did she tell you how she knew he was just trying to scare him and not trying to shoot him?
No, ma'am.
She didn't say that he said that to her or anything like that?
Ma'am.
Okay. Did you ever go out to the location?
Yes, ma'am.
And were you able to find any bullet casings or?
No, ma'am, I wasn't.
Okay. Did you ever speak to the defendant, Mr. Vaughn?
Yes, ma'am.
Did you ask him about the incident?
Yes, ma'am.
And what did he indicate to you?
He informed me that, he did go over there, and that him and Mr. Mitchell did have words. He stated that he did have a gun on him. He stated that he did fire a shot. I think he said he don't know why he did it, kind of a reaction thing. He stated that he never intended to hurt Mr. Mitchell. It just something that kind of happened.
Did Mr. Vaughn ever indicate to you that he knew the children were in the back seat?
I can't recall.
Okay. Did he ever describe his gun to you?
No, ma'am.
Okay. Did he ever show you a picture of his gun?
No, ma'am.
Did you ever talk to the minor children involving regarding the incident?
No, ma'am.
Okay. But you do know it was 2 children.
Yes, ma'am.
Okay. Was anyone ever injured as a result of this?
No, ma'am.
Okay. Did Mr. Mitchell tell you that, well, let me rephrase that. Did Mr. Mitchell ever indicate to you that he had physically harmed Mr. Vaughn?
No, ma'am.
Did he ever indicate to you that he had threatened Mr. Vaughn?
No, ma'am.
Did Mr. Mitchell ever indicate to you any reasoning as to why this had occurred?
Nothing besides that they just, both of them didn't too much care for each other.
Okay. When you arrested Mr. Vaughn, did you read him his Miranda warnings?
Yes, ma'am.
And forgive me for asking again, but I can't quite remember. Are you post-certified?
Yes, ma'am.
Were you at the time of this incident, which was March of 2023?
Yes, ma'am.
Okay. You've charged Mr. Vaughn with aggravated assault. What was your probable cause basis for that?
When I spoke with Mr. Mitchell, he insisted that the defendant shot at him, but he missed him. So that's why I charged him with aggravated assault.
Anything else?
No, ma'am.
Okay. The defendant is also charged with reckless conduct. What was the probable cause basis for that charge?
The location of where Mr. Mitchell described the shooting took place was a bunch of apartment buildings by there. The reason why I charged him with reckless conduct, because bullets don't have no name on them. It's kids, parents, families that stay in those apartment units. So that's why I charged him with reckless conduct.
Okay, and just to be specific about the location of the incident, did anyone indicate to you where, and positioning wise, the car was and Mr. Mitchell was?
When I looked at Officer Armitroff's body cam, Mr. Mitchell took him back to the incident location and kind of walked him through the incident and showed him exactly where he was standing and where the car was.
Okay. Was Mr. Mitchell's back towards the apartment complex?
Yes, ma'am.
Okay. Was Mr. Mitchell facing the car when he was shot at?
Yes, ma'am.
Okay. So did Mr. Mitchell indicate that he saw the entire thing happen?
Yes, ma'am.
Did Mr. Mitchell indicate that he ducked or ran or tried to get out of the way?
He said when a shot was fired, he kind of moved out the way a little bit.
Did Mr. Mitchell indicate about how long it took? Like, was it fast? Was it slow?
No, ma'am.
Okay. Did Mr. Mitchell indicate to you how long he had known Mr. Vaughn?
I can't recall.
Okay. But he was able to point him out via Instagram?
Yes, ma'am. After I was able to identify who the defendant was, he was placed in a photo lineup, and Mr. Mitchell picked him out of a photo lineup.
Okay. Is there anything else that you learned during this investigation that we've not covered here today?
No, ma'am.
Okay, nothing further.
All right. Kennebrew?
Yes, Your Honor. Thank you. Hello, Officer Snow.
How you doing?
And you were not the responding officer, is that correct?
That's correct.
And can you spell the name of the responding officer? I believe you said it was Armitrov.
Yes, ma'am. That's ARMENTROUT.
Armitrov, okay. And you stated that you did take a statement from the alleged victim, Mr. Mitchell, correct?
Yes, ma'am.
And that would have been taken by Mr. Armitrov or Officer Armitrov as well?
I took a statement from him as well. I believe he provided Armitrov with the statement. I also took a written statement from him as well.
Okay, and you stated that Mr. Mitchell came into the precinct to file a report?
No, ma'am.
I'm sorry, what did you say?
He contacted 911 after the incident occurred.
Okay, but it was was it on the same date that the incident occurred?
Yes, ma'am.
And when you spoke with Mr. Mitchell and he gave his written statement, did he tell you where the gun was aimed at when it was fired, allegedly fired?
No, ma'am.
So he didn't say it was aimed at my head or it was aimed at my body or it was aimed, he just stated it was a gun that was fired?
No, he just said that the defendant tried to shoot him. He didn't give a location of where he tried to shoot him at. He just said he tried to shoot him.
And do you happen to know how far from where Mr. Mitchell was my client? So where the car was in reference to where Mr. Mitchell was standing?
When I asked him, he told me probably about 10, 15 feet.
Did Mr. Mitchell describe the gun?
No, ma'am.
And I believe on direct, you stated that you went back to the scene. Is that correct?
That's correct.
And so did Mr. Mitchell show you when you guys went back to the scene where he was standing during the incident?
Yes, he also walked me through the incident as he did with Officer Armitrage as well.
And you stated on direct that you did not find any bullet fragments, correct?
That's correct.
And were you wearing an operational body camera during that portion of your investigation when he walked you through?
Yes, ma'am.
And did you view that footage in preparation for today?
No, ma'am.
Has that footage been submitted to the state or at least preserved?
It's been preserved. I don't know if it's been presented to the state.
Did the apartment complex have any surveillance cameras in the area?
They do have surveillance cameras, but the incident wasn't caught on any of the cameras.
So you all did obtain the footage from the cameras?
No, ma'am.
How are you aware that it wasn't caught on camera?
I asked management. The cameras where the incident took place was down on that particular day.
And you also took a statement from Ms. Goins?
Correct.
And what was her involvement in the incident?
She was the driver of the vehicle during the time of the incident.
And was she present for the firing of the weapon?
Yes, ma'am.
In her statement, Ms. Goins stated that she did not attempt, in her statement, Ms. Goins stated that Mr. Vaughn did not attempt to shoot at Mr. Mitchell. Is that correct?
That's correct.
And she stated to you that he was attempting to shoot at the ground. Is that correct?
That's correct.
And during your conversation with Ms. Goins, did you have your body camera on?
That's correct.
And it was operational as well?
When she came into the station, the interview was recorded.
And then you stated that you also spoke with Mr. Vaughn. That's correct?
That's correct.
Where did you speak with Mr. Vaughn?
At the police station.
And at what point did you speak with him?
After he was arrested.
So he was in custody?
That's correct.
Was he read his Miranda warnings?
Yes, ma'am.
And when you spoke with him, you stated on direct that he informed you that they did have words, he had a gun on him and he fired a shot. Is that correct?
Who, Mr. Vaughn had a gun on him and he fired a shot?
Correct.
That's correct.
So Mr. Vaughn did admit to you that he fired a shot from a gun?
Yes, he did.
And then you said on direct that he also stated he didn't know why he did it, but that he didn't intend to hurt Mr. Mitchell. Is that correct?
That's correct.
And when you were speaking with Mr. Vaughn, did Mr. Vaughn ever state to you that Mr. Mitchell was on top of the vehicle refusing to move unless he was paid $2,000 in tax money?
I have to go look back at my report, but I think so.
And when Mr. Vaughn was arrested, did he resist arrest?
Not to my knowledge. He was arrested by Henry County PD.
And so you wouldn't be aware of if he was Mirandized either
Well, with Henry County?
when he was arrested, correct?
No, when he was arrested by Henry County, he sat in Henry County Jail for a couple of days before he was transported to College Park.
And did either Mr. Vaughn or Mr. Mitchell ever inform you of any previous incidents between the two?
I can't recall. I know Ms. Goins did tell me that they had previous altercations before.
And what did she state happened at those previous altercations?
She just informed me that they didn't like each other and they had words before. She didn't really go into detail.
Did either Mr. Mitchell, Mr. Vaughn, or Ms. Goins let you know that they had been physically in an incident physically before?
With Ms. Goins?
No, excuse me, let me rephrase it. Did Ms. Goins or Mr. Mitchell or Mr. Vaughn ever state that Mr. Mitchell and Mr. Vaughn had ever been physical with each other before?
I can't recall.
Can I have a moment, Your Honor?
Yes, ma'am.
Your Honor, those are all of our questions currently.
Anything else on direct?
Yes, Your Honor, I just wanted to ask one question. You did testify to Ms. Kennebrew that you did speak to Ms. Goins and that she had mentioned a previous issue between Mr. Mitchell and Mr. Vaughn. Did she ever state that, and you might have already answered, so forgive me for asking again, did she ever state that they had been physical before?
I can't recall. I did remember her saying that. I don't think it ever got physical. I think it was just words between the both of them.
And we will
Okay.
object for speculation because he doesn't know for certain.
Yeah, try not to speculate. Just, if you know, you can answer. If you don't, it's okay.
Okay, but you can't recall is the answer.
I can't recall.
Okay, correct. Also, you did state on cross with Ms. Kennebrew that they had an issue that day. Is that correct? Mr. Vaughn and Mr. Mitchell, were they arguing that day?
From my understanding, that Mr. Vaughn, the issue was with Mr. Mitchell and Ms. Goins regarding tax refund money. From my understanding, the defendant just kind of got involved because he was with Ms. Goins on that particular day.
Got involved, what does that mean?
He kind of got involved in the situation because he was in the car with her that day.
How did he get involved?
Far as, I guess, Mr. Mitchell, kept telling Ms. Goins that you're going to give me my money, you're going to give me my money. And that's how things kind of escalated.
Okay. All right, nothing further from this witness.
Ms. Kennebrew?
No, Your Honor.
Thank you, Detective. Stay safe out there. Thank you for being patient.
Thank you.
All right, go ahead with the argument.
One second, Your Honor.
Sure.
Thank you for coming back.
Your Honor, we would go ahead and submit to the evidence, to the testimony on these two charges.
Okay. Anything else?
No, Your Honor, we would submit to the evidence as well.
Okay, so we'll find probable cause on both. Now you want to go ahead with your bond argument?
Yes, Your Honor.
And wait.
We already heard, he has 5 cycles, no felonies.
We did hear from
He
them.
had possession of marijuana less than an ounce.
Right.
So no, we do not need to hear from pretrial, Your Honor.
Is he on a no bond status?
He is on a no bond on the first charge.
Okay.
Yes.
Yeah.
All right. Mr. Vaughn is 24 years of age. He did, as the officer even testified, go to Clayton County first before being brought over here. He has been in custody here for 67 days. Your Honor, he was born and raised in Georgia. He does currently reside with his aunt, and that will be in Locust Grove, Georgia. So that is not in Fulton County. He did complete his high school diploma. He was working prior to arrest at Radio Warehouse, and he had been working there for 7.5 months. Your Honor, he does currently support his children, and he is obligated to pay child support for those children. As we heard from pretrial, he has no felony convictions. He only had 1 serious offense that was from last year, Your Honor. Everything else, I believe. Oh, actually, no, I'm sorry. That's the wrong person. He didn't have any serious offenses, no felony convictions. The offenses that he did have was minor possession of marijuana. We would be requesting that the bond not exceed $15,000. We would say 10,000 on count 1 and 5,000 on count 2.
Yeah, right now, Ms. Patton, it's split 0 on ag assault and 25 on reckless conduct. So go ahead.
2,500 or 25,000 on reckless conduct?
Mhm.
Your Honor, I was going to request 35 in total with 25 on the ag assault and 10 on the reckless conduct. I'm not sure if you have reckless conduct as a 25,000. I guess you can lower it.
Yeah.
It's a misdemeanor, so we will be requesting that it be lowered. And we also want to remind the court that the bond isn't to keep the client in custody. It isn't to actually punish him. There we go. That is the word. Punish him before trial, Your Honor. It is to ensure that he would come back to court. He didn't have any FTAs in his history. He doesn't have any violations of probations or anything like that. So again, we would be requesting a $15,000, no higher than a $15,000 bond. Again, he only has 5 cycles, no felony convictions, only misdemeanors.
Your Honor, my basis of my bond recommendation is based upon the fact that this defendant and this victim have had previous interactions, and now it has escalated to a gun being fired. One of the factors that we are supposed to consider in terms of setting a bond is a danger to the victim and a danger to the community as inherently dangerous by firing a gun, outside of an apartment complex.
And there were circumstances where where my client could have been provoked, seeing as the officer did testify to hearing that the complaining witness was on top of the vehicle and then refusing to move before getting a payment.
That's right. All right, let's see. No drugs unless prescribed, no alcohol, no weapons. Stay away from 2210 Sullivan Road in College Park. No further contact with Perry Mitchell. Stay out of Fulton County unless you're here for court or to see your lawyer. So no more going to exchanges for the child. So you don't need to be there when Ms. Goins exchanges the children with the father, Mr. Mitchell. You're gonna have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, the exact location you'll be working. I think you said you also have minor children, so anything having to do with your minor children and basic life necessities. Stay out of Fulton County, sir. Court, lawyer, that's the only reason you come here. And you do not, and Ms. Williams put that in, he does not go to exchange of the minor children with Ms. Goins. He cannot go there. I'm not going to put that he stays away from those minor children because I guess since they're boyfriend and girlfriend, that would keep them apart. So that ankle monitor will be paid for by the county. All right. 10,000 count 1, 5,000 count 2.
Thank you, Your Honor.
Best of luck to you, sir. I don't think you had any holds, but if you did, you get the regular 48 hours to have that ankle monitor placed on your ankle.
You didn't see anything, Your Honor.
Now we can bring out that last person that we talked about. We can actually bring out Jamison Curry.
Oh, yeah.
Last one,
Yeah.
Jamison. If we could bring out the real Jamison Curry this time. And we'll just tell him it's still reset till June.
Your Honor, can I have the name of the girlfriend again? I'm sorry.
Rachel Goins.
Goins.
ES.
Yes, I'm sorry.
Goines. Okay. God, she's right.
Well, I guess so. That's only because it's mostly just recess. Maybe we'll get a nap.
What you need a nap for? You said you're not on the 5 o'clock calendar.
I
Right,
have to
see,
prep tomorrow's.
we are on the 5 o'clock calendar.
God, no.
Okay.
And they're trying to make me work Juneteenth.
Doing what? Oh, on call?
Don't let 'em-
First appearance.
Oh,
And,
yeah.
listen, I'm gonna say something uncomfortable, but like I'm Black.
Yeah.
Why should I have to work it? Like, that's literally kind of what it's for.
Listen, to celebrate.
And I just worked Memorial Day.
Oh, they're making, they usually don't make people work 2 holidays in a row.
Call my boss. Tell someone, please.
That is kind of wild.
Jimmy, call Miss Willis and I'll tell her.
And it's-
Actually, you
yes,
know what? I
fall.
think if Miss Willis knew, I think she wouldn't do that. I think the problem is she doesn't know.
I thought maybe they weren't having it. I just didn't know.
No, first appearance. And for Memorial Day, it was 65 people.
Oh, yeah. It's
I
a
was in
holiday.
there
It's
all
fine.
day.
Yeah, it's a lot.
That's him, yes, sir.
I think it was Judge Hughes. At least she goes faster.
I'm telling you.
We tried, and it was Miss Hustis, who's pretty fast too. I mean, we tried. We were in there almost to 5.
Yeah.
Yeah, because it is 8 + 7 is, that's 15.
So Miss Kennebrew, that's for sure Mr. Curry, right?
Correct. It's
Okay.
Mr. Curry.
All right. All right, 23 CP 217637, Jamison Curtis Curry, still 65 days without indictment. Death by receiving stolen property, driving, fleeing, attempt to elude, possession of a firearm or knife after the commission of a felony, driving hit and run, and reckless driving. There is a $15,000 is a split bond as of April the 13th. Right now, before we hear from pretrial again for him, we're going to reset this for June 30th. Mr. Curry, they've put on the record that we don't know. It seems like the officers may not have got subpoenaed in time to be here. So we're going to reset the prelim until June 30th, but we're still going to address your bond today, which is probably what you're the most interested in anyway. So we will address your bond today, and your prelim, if you don't bond out, will be June 30th at 1 p.m. And right now you have that $15,000 split bond. So
26 cycles, aggravated assault conviction 2022, possession of cocaine conviction 2019, appears to be on probation for armed robbery, aggravated assault, hijacking a motor vehicle, criminal damage to property, and possession of a firearm by a convicted felon. That case was from 2007. It was 11 years confinement, 9 years probation. Burglary conviction 2003, 2004, and 2000 conviction for theft by receiving stolen property, 1 FTA, and 3 probation violations.
And this is for defendant Jamison Curry, position 7.
Yes.
just making sure. Okay, go ahead.
He's in a no bond status on which ones?
The first 3 counts.
Okay, theft by receiving, driving, possession of firearm. Okay.
Right.
I don't know what it is. They can- I'm sorry, Your Honor. Can I have a moment?
Sure. Was it raining outside?
I'm not sure. It wasn't earlier. It was really pretty.
Yeah, I walked down the subway. It was pretty. It's supposed to rain. Of course, it'll start raining and thundering by the time we get on tonight.
I'm sorry, pre-trial. Can you read out his history again?
From the beginning,
Yes, I'm sorry.
26 cycles, 2022 ag assault conviction, 2019 possession of cocaine conviction, appears to be on probation for armed robbery, ag assault, hijacking a motor vehicle, criminal damage to property, and possession of a firearm by a convicted felon. That's from 2007. It was 11 years confinement, 9 years probation. Burglary, 2003 conviction, and 2 theft by receiving stolen properties, 2004, 2000, 1 FTA, 3 probation violations.
Thank you. I'm sorry. So Mr. Curry just informed me that the possession of cocaine, he is saying that isn't his history, that isn't a part of his history. So we just wanted to put that on the record. However, Mr. Curry is 41 years of age. He was born and raised here in Georgia. He does currently live with his brother at a home in East Point, Georgia, Your Honor. He did graduate from high school. He was working at Waste Pro for 2 years prior to his arrest. He is inclined for me to ask for a UJR to his Clayton County hold. If you are not, or to his probation violation hold. If you are not inclined to get a UJR for either of those holds, Your Honor, we would ask that the bond not exceed $11,000. That would be split with the $3,000 on theft by receiving, $1,000 on driving, fleeing, or attempting to elude, $5,000 on the possession of a firearm, $1,000 on driving hit and run, and $1,000 on the reckless driving. The alleged theft by receiving stolen property is a 2012 car, and we would just be asking that of the court, Your Honor.
All right, Ms. Patton?
Your Honor, the state is requesting that you leave the bond amounts as stated for the bottom two charges, the first three of which having been assigned to no bond status. I believe Your Honor is capable of setting bond on the 91st day. The reason for that being is this defendant does have theft in his history, and while it looks like it's a long stretch of nothing, he was incarcerated at that time as read out by pretrial. We believe this defendant poses a significant likelihood to reoffend, and we'll leave it up to Your Honor's discretion on whether or not on the amounts for bond.
Are you asking to not let the bonds go into effect until the 91st day?
Correct.
Or you're fine?
Correct. That's what the
Okay.
state's asking, yes.
All right, let's see. And they're VOP holds, right? Pretrial, I'm sorry.
Let me go double check.
I'm sorry, I can't read my handwriting. I could the first time, but now how much time has passed, I think.
His history hasn't been ran since he's been in custody. At that time, it didn't appear he had any VOP holds. I mean, since he was arrested, it was when his criminal history was ran. I can run it right now and check if you need me to.
You thinking, what are you thinking he has? What are you thinking he has?
On his Odyssey, it says it's a probation violation hold as well as a foreign county hold.
Oh, yeah, Clayton County, and then, yeah, okay, I see that, yeah. Oh, the probation is here too, yeah.
Oh, I didn't notice it was here.
Yeah, let's see, the probation's here. All right, let's see, no drugs unless prescribed, no alcohol, no weapons, no further contact with Apeksha, Apekasha, middle name Arun, last name Patel, Patel. You have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment, schedule, the exact location you'll be working. Also, we'll give you some basic life necessities. And you have 48 hours to have that ankle monitor placed on your ankle once you get released from your hold. Let's see. Wait, let me find that real quick. All right, so I'll do 5,500, 5,000 and 7,500. 5,500, 7,500, 5 and 7,500. Got that, Ms. Williams?
Your Honor.
Thank you, Ms. Williams.
Thank you, Your Honor.
And that's it. Best of luck to you, sir. And that is it until 5 o'clock. Same bat time, same bat channel, right? Except for you.
Give me 1
Yeah,
second.
Miss Kennebrew.
Always.
Well, I'll see you tomorrow.
That's
All
one.
right, yeah, we'll have prelims tomorrow. Somebody else is covering TPOs for me. It's been heaven. Somebody's covering them for me where I get a break from TPOs.
I love
Alright, Desmond,
TPOs.
So come back to you.
I know, well, like Ms. Watts, after 15,000, I'm.
16.